Hello and welcome. My name is Mahmudul Hasan. I'm an immigration attorney. I have been practicing immigration law in the United States for the last 6 years. So far, I have worked on almost all types of immigration classifications. I have grown my expertise in employment-based immigration, investment-based immigration, immigration litigation, and so much so forth. I have gained my own permanent residency in the United States through an EB1A petition, and I have a special expertise and insights on EB1A and EB2 national interest waiver petitions. In this EB1A series, we are going to cover comprehensively the EB1A classification. We break down this series into 14 parts and we will comprehensively discuss each and every EB1A criteria. We break down each and every EB1A criteria into different components and we'll see what documents you should submit in order to satisfy that component of the EB1A criteria, and also what other things you have to consider before submitting your petition. We provide a directory in the description of each video to find the right part you are looking for. Let's dive into the video. Before we discuss the EB1A, I want to lay out the foundation of employment-based immigration in the United States. Two types of visas are generally given: immigrant visas where you come with a green card or permanent residency, and non-immigrant visas where you come temporarily. Several types of non-immigrant employment-based visas are given temporarily to work with the US employer, such as H1B, L1, O1, P, T, TN, Q1, R1, and so forth. To become a permanent resident based on an employer's petition, there are 5 classifications: EB1, EB2, EB3, EB4, and EB5. The names also represent the order of preference. EB1 is the first preference, which means among all types of petitions, EB1s are adjudicated first. There are 3 types of EB1 visas: EB1A, EB1B, and EB1C. We are discussing EB1A, which is the first priority employment-based visa leading to permanent residency. We have divided our discussion on EB1A into several parts. We will have an extensive journey on different aspects of EB1A through this series. In this part 1, we will start with an introduction to this classification. We will briefly explore the scope of expertise covered under this classification. Following this, we will highlight the notable advantages that come with securing an EB1A based green card. Then we will briefly discuss the eligibility criteria required for petitioners to qualify under the congressional statutes, federal regulations, and case laws. This is the only part where we will discuss some legal aspects of this EB1A classification. We will have some discussion on the evidentiary standard to prove your extraordinary ability, like preponderance of evidence and comparable evidence. Otherwise, we will try to avoid any kind of complex legal discussion and we will try to make this as comprehensible as possible. Finally, and most importantly, we will discuss how USCIS determines whether you qualify or not for this classification in different stages. Stay tuned as we navigate through the complexities of the EB1A petition. We intend this series to be explored mostly by petitioners who are interested in this classification. But we understand that this series will help many early career and aspiring attorneys as well as other professionals who are interested in learning about EB1A. This series is presented for educational purposes only, and it does not constitute any attorney-client relationship between you and me or anyone associated with me. Immigration law is complex and every case requires personalized attention. Please consult with an experienced immigration attorney before you make any immigration decision. Additionally, we will present several case studies illustrating different aspects of the petition and regulatory criteria. The case studies we present here are fictional, and if any aspect of the case study is coincidentally identical to someone, we are not responsible for that. Let's start by unpacking what EB1A stands for. The EB1A classification falls under the United States Employment-Based First Preference Immigration Classification, designed for individuals who have demonstrated extraordinary ability in their respective fields, ranging from the sciences, arts, education, business to athletics. This classification stands as a recognition to extraordinary ability and sustained national or international acclaim. Now you might wonder what fields qualify for this extraordinary ability classification. EB1A offers to a diverse array of fields including but not limited to various engineering disciplines, software development, applied sciences such as biotechnology, arts ranging from visual to performing arts, social sciences, education sectors, business, athletics with Olympic level achievements, medical fields, and other specialized areas like law and linguistics. EB1A regulation mentions 6 generic fields and most of the occupations are covered under those 6 generic fields. Consider some examples such as a famous chef or a renowned mixologist specializing in the art of cocktail creation might qualify as artists of extraordinary ability. Overall, if you have a well-documented expertise in a field, EB1A petition might have a room for you. What are the advantages of an EB1A petition? Let's unpack the advantages it offers to those who qualify. First off, the EB1A allows self-petitioning. This is a game changer. It means you don't need a job offer from a US employer to apply. This opens up a world of possibilities for independent professionals and those yet to secure a position in the US. It offers an unparalleled flexibility. Second, unlike other employment-based visas, the EB1A skips the labor certification or perm process. This step usually requires employers to prove the absence of qualified workers in the US for the job, a requirement that can be time-consuming. Exempting from this process can significantly speed up your petition journey. Third, the EB1A category often enjoys lower backlog than other employment-based petitions. Obviously, you know the reason: it has lower number of petitioners. It reduces the wait time for a visa to become available, especially for petitioners from high-demand countries like India, China, Philippines, and Mexico. Fourth, this is a first preference visa. On top of lower backlog, EB1A enjoys high priority in the visa allocation process, contributing to potentially faster processing and adjudication times. Fifth, once you have the EB1A visa, the world is yours. You can change jobs or employers with minimal impact on your immigration status, because the visa isn't tied to a specific job or employer. Sixth, although this is not exclusive to EB1A, it extends its benefits to your immediate family. It allows your spouse and unmarried children under 21 to obtain green cards as dependents at the same time. Seventh, getting your green card through an EB1A petition is an indication of your achievements and recognition of your expertise. It enhances your professional profile. Who is eligible for EB1A? Section 203B1A of the Immigration and Nationality Act lays out the foundation of EB1A. It requires you to prove 3 things. First, you have extraordinary ability in the sciences, arts, education, business, or athletics, which has been demonstrated by sustained national or international acclaim, and your achievements have been recognized in the field through extensive documentation. The statute, however, does not explain how you can demonstrate this extraordinary ability. Federal Regulation 8 CFR 204.5H provides details on how you can demonstrate your extraordinary ability. We will discuss this in the subsequent section of this video. Let's finish our discussion on the Immigration and Nationality Act. Second thing INA requires. In addition to your extraordinary ability, you have to demonstrate you will continue working in the field of your extraordinary ability once you are granted the green card. Many people often forget to argue that they will continue working in the field of the extraordinary ability. As a consequence, they receive an RFE. If you look carefully, this is as important as proving your extraordinary ability, because INA requires it. Now, how you can demonstrate it? Simply, you have to add a section in your personal statement or legal support letter that you will continue working on the field of your extraordinary ability. The third thing INA requires, and many people often ignore this, you must demonstrate your entry in the United States will bring substantial benefits to the country. This is broad and easily achievable, but you have to demonstrate it. How you can demonstrate it? Different people might have different strategies. One easy way is search on the internet, find the market size of the field of your expertise in the US, shortages, challenges, and other possible data, statistics and reports, the global position of the US in that field, and so forth. Now, make an objective or general argument on how, with your expertise, you can address that problem, you can fill that shortage or advance the field. You don't need to be very specific. You can make a very general argument. But if you don't argue it, USCIS has discretion to issue an RFE or deny the petition. That's all about INA. Now, how you can demonstrate your extraordinary ability as required in the first prong of INA. Federal Regulation 8 CFR 204.5H provides that you can prove your extraordinary ability for EB1A in two ways. First, by demonstrating a one-time significant achievement recognized on an international level, such as a Nobel Prize or an Olympic medal. Second, or by meeting at least 3 out of 10 specific criteria. These criteria are: 1. Evidence of receipt of lesser nationally or internationally recognized prizes or awards for excellence. 2. Evidence of your membership in associations in the field which demand outstanding achievement of their members. 3. Evidence of published material about you in professional or major trade publications or other major media. 4. Evidence that you have been asked to judge the work of others, either individually or on a panel. 5. Evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance to the field. 6. Evidence of your authorship of scholarly articles in professional or major trade publications or other major media. 7. Evidence that your work has been displayed at artistic exhibitions or showcases. 8. Evidence of your performance of a leading or critical role in distinguished organizations. 9. Evidence that you command a high salary or other significantly high remuneration in relation to others in the field. 10. Evidence of your commercial successes in the performing arts. We are making one comprehensive part for each criterion where we discuss in detail what does that specific criterion mean. We break down each element of each criterion and other possible issues that you have to prove to satisfy that criterion. We also discuss a list of documents you can submit to prove each element. We also provide a guideline on how you might find those documents. Follow our whole EB1A series for a complete understanding on this classification. Please note that we have provided a directory of the EB1A series in the description of each part to make it easy to find and follow. We have discussed the federal regulations. Now, case laws or case decisions by different US courts also shape the framework or the legal standard of EB1A classification. The subsequent segments of this video will discuss some legal standards that derive from the case decision. We will skip the discussion on the case itself and we will focus on the principle they provide. First, standard of proof. In other words, to what extent you are required to prove your extraordinary ability. In most of the immigration cases, the USCIS employs the preponderance of the evidence standard. It means that you have to demonstrate it's more likely than not you meet the EB1A criteria. In layman language, we say that you have to prove your case by more than 50%, which might not necessarily be the exact standard, but at least it explains what is preponderance of the evidence. Preponderance of the evidence standard is more lenient and easy to achieve than the other evidentiary standards like clear and convincing and beyond reasonable doubt standards. However, we are not discussing that here. Just you have to remember you have to prove your case by more than 50%. One example might help you understand this more clearly. The petitioner, Dr. Jane Smith, is a scientist specializing in genetic research. Each piece of evidence she submits is not required to independently establish her qualifications, but rather each piece of evidence contributes to a cumulative case that aims to meet this threshold. The evidence she submitted collectively should convince USCIS that there is a greater than 50% chance she satisfies the specific regulatory criterion when they assess a specific criterion, or she is at the very top of her field and qualifies for the classification when they assess her sustained national or international claim. Next, comparable evidence and when it is accepted. The regulation allows comparable evidence. This is particularly useful when standard criteria don't directly apply to your profession. Regulation recognizes that excellence can be demonstrated in various ways depending on the nature of your work. For example, if you're in a field where publishing scholarly articles isn't common, like in certain industrial sectors, presenting at a major industry conference might be equally significant. Or if you're an entrepreneur The value of your equity in a successful startup could be just as indicative of your extraordinary ability as a high salary would be in other professions. This flexibility extends to various scenarios and might be useful for your case. How USCIS should assess the extraordinary ability and determine the sustained national and international acclaim. Once you submit an EB1A petition, USCIS employs a two-step evaluation process for EB1A petitions. In the initial evidence phase, USCIS determines whether the submitted evidence meets the regulatory criteria. For example, if you are claiming a significant one-time achievement, such as a major internationally recognized award. USCIS determines whether that one-time achievement is as significant as you are claiming through preponderance of evidence standard, or if you are claiming you satisfy at least 3 out of 10 regulatory criteria or be comparable to these criteria. USCIS determines one by one whether you satisfy the individual criterion. For example, you are claiming your authorship of scholarly articles in professional or major trade publications or other major media. USCIS determines whether you authored the article or not. Then USCIS determines whether the article is scholarly or not. Lastly, USCIS determines whether the forum where you published your article is a professional or major trade publications or other major media. Once USCIS determines that you satisfy at least 3 out of 10 criteria, it then moves to the second stage determination process. This is called final merits determination. In this stage, USCIS determines whether you have achieved sustained national or international acclaim and is recognized in your field, whether you are among the top of your field. USCIS determines the sustained national or international acclaim through the entire petition. As discussed, it applies the preponderance of the evidence standard to determine that. One example might help you understand this more clearly. A visual artist whose work has been exhibited in several countries and has significantly influenced contemporary art. The petitioner submits the evidence of solo exhibitions in internationally renowned galleries, critical reviews published in major art magazines, and significant sales prices at international art auctions. In this stage, USCIS considers the wide international exhibition history, critical acclaim in respected publications, and high auction sales as indicators of the artist's sustained international acclaim.
We are ending our discussion on the fundamentals of an EB1A petition. In subsequent parts, we will be covering all EB1A criteria part by part. Please follow us on Facebook, YouTube, and LinkedIn. We will cover other immigration issues in our subsequent videos. Once again, please consult your immigration attorney before you take any immigration action. Thank you very much for watching this.